Hey, good afternoon, everyone. In Introduction to Law, I'm going to put up a quick video summary of Chapter 10 in our book. That's related to family law. This overlaps a lot, or it's a nice summary, actually, for those of you who end up taking family law. I think some of you might be in that course right now. It's only offered online at this juncture at the moment, but it's a great course to really fill in a much deeper dive, if you will, on these sub-issues. This is a survey course, so we're just going to touch on the sort of the cornerstones of some of the important aspects of what family law is. Book does a great job. You don't need to hear me read from the book or state the same exact information. I just want to sort of summarize some of the things that I think are critical from this chapter if you like hearing a lecture. So that's what we're going to do. So one is family law has changed significantly, certainly over the past century, even in the past few decades. There's been substantial changes in family law in terms of eligibility regarding who can marry. And those of you that know that, first it started with the states having looked at their own state laws and state constitution to determine whether or not the right of marriage should be recognized for gay and lesbian couples. And we know Massachusetts was on the forefront of that. In that, a lesbian couple actually was denied a issuance of a license to marry. They challenged that. It went to the Massachusetts Supreme Court. It's called the Goodridge case. Actually, one of the litigants in it was a law professor from the law school they went to, West Point Law School in Springfield. And they took it to the Supreme Judicial Court, arguing that under the Massachusetts state constitution, gays and lesbians are identified as a class of people. No class of people within the state of Massachusetts can have any of the rights and privileges and laws be unapplicable to them or equal to their position. And they prevailed. And so gay marriage was allowed in Massachusetts. Other states had similar rulings after Massachusetts, but then other states, many of them south of the Mason-Dixon line, specifically banned marriage other than between one man and one woman in their state constitutions if it wasn't already interpreted as such. And so we had this very, very challenging situation under federalism where a significant portion of the country was recognizing the legitimacy of gay and lesbian couples, and another significant portion of states was not. And then sometimes couples would come from areas that didn't recognize the validity of marriage, marry in a state like Massachusetts, move back home, but be denied the rights and privileges of the legal standard of being a married couple. We know that all changed under federal law in the past decade in a case called, I believe it's Hodges. In Hodges' case, they finally went to the Supreme Court where they argued under the Equal Protection Clause of the 14th Amendment to the United States Constitution, no state should be able to deprive a gay and lesbian couple from marrying because there's no compelling interest in the government from denying such a privilege. And privileges, immunities, and legal standards should apply equally to any identifiable class of people. Is a class of people or a group of people being recognized as gay or lesbian categorized succinctly enough and clear enough that they should be offered the same rights and privileges as heterosexual couples, just like white people, black people, Hispanic people, people of certain different kinds of religions. These are identifiable classes of people that should be given the same rights and obligations and privileges under the law as anybody else. And they prevailed. And so now gay and lesbian marriage is legal throughout the United States. There are still some standards that are allowed to be placed before certain groups that denied them the right to marriage. Age, for example, we don't allow. Hopefully, we don't in too many jurisdictions. Hopefully, fairly nationwide. But there's some differences, obviously, between some states and other that we limit very young people from marrying. We also limit people with mental impairment such that they wouldn't have the ability to enter into a valid contractual arrangement because they don't have the mental wherewithal to understand the nature of the obligations of what it is to be in a legally binding marriage. And so those are some of the restrictions. There's also other restrictions about having only one spouse. Somebody say, well, they allow that out in Utah. No, they don't. People do it perhaps, and perhaps the law doesn't necessarily catch up with some of these people, but you're only allowed to have one legal spouse, and you're only allowed to have one marriage at a time. So even if you break up with the other spouse, you have to formally have that marriage concluded through a divorce or an annulment before you're allowed to marry another couple. Another couple. That's you only have one spouse. You can't marry a couple. You can only have one spouse at a time. And so the book does a nice job talking about some of the history of marriage. Some people that don't like gay marriage. It's fine to have your own opinion about things like that, but the reality is they sometimes get to this sort of argument saying, well, now anything goes. Anybody can marry anybody or anything they want. People will suggest that somebody married their car recently. There'd be some silly story in some social media section that someone recently fell in love with their car and married it, or they're going to marry their pet or their child. You can't, because there's laws banning that about incestuous relationships, and it's only involving human beings being eligible to marry, because you have to have the capacity to do so. So it's not quite as broadly a sweep and change as some people would suggest, but it does apply now to gay and lesbian couples. As consenting adults have the same rights as any other adults to enter into the legal arrangement of marriage. Now, some people say, well, this is really inappropriate because the right to marriage is a religious concept. Well, it was historically, no question about it. But what we're talking about here is not the religious standard of some faith. We're talking about the government sanctioning and recognizing somebody as a legally married couple. Religious groups are not required to grant a marriage ceremony to a couple that they disapprove of under their religious dogma. So if I had a religion Z and we opposed gay and lesbian activities and marriage, we would not be required under the law to perform a marriage ceremony for them. But the government would still issue that couple a license, and they would determine whether they're going to have a civil ceremony before a justice of the peace or some other religious group that might well recognize that marriage ceremony as acceptable under their religious standards. So you don't have to get too deep on that. Most of the time when you're practicing as a paralegal and attorney, you're not going to have too many cases where you're going to go and fight to try to help somebody to become eligible to get married. Those are narrow kind of questions that aren't going to come up that much in the common practice of family law. Now, just as an interesting point, some of you want to become paralegals, some of you want to become attorneys. There's plenty of work in this area. It's still around 50%. It's dipped a little bit under 50%, I believe, in recent years, but basically half of all married couples will divorce, and significantly more of second marriages will actually fail in divorce. That always surprised me, but statistically, there is plenty of legal work in the realm of divorce. There's also plenty of legal work in the realm of family law, even if couples don't marry, because if they have offspring and children together, there's often issues of support and custodial arrangements that, although agreed upon, might need to be litigated in order to protect not only the children's rights and obligations, but also the parents, even though they were never married. One of the ways we end marriage, there's really three ways in which the legal status can be altered, and one is annulment. That's not going to come up too much, and I want to draw a very clear distinction between religious annulment and legal annulment. We're not going to talk about religious at all, other than just to mention that's what probably most of us have in the back of our mind until we get into some legal training. Like if you grew up Catholic or you know people who are Catholic and they marry and they get a divorce, it's considered to be a violation of the tenets of the Catholic faith to get a divorce. So to stay in good stead with your church, you might want to end that marriage through not only the legal channel of a divorce perhaps, but you might want to seek an annulment through your church. That we're not going to deal with. I don't know the rules there. Usually cost a fair amount of money, and you go through some church protocol. And other faiths have it too. It's not just the Catholic faith. Other religious groups have a process of annulment that the faith, the religious organization will recognize your marriage has ended. That does not impact the legality of your marital relationship. To get an annulment in law, you have to file a complaint for annulment in the appropriate probate and family court. That's what we call it here in Massachusetts. And how that will work is, and the reason why it's so narrow, is an annulment is a declaration that there was never a valid marriage. So there will be no potential for alimony of paying support for the other spousal party, and there will be no division of marital assets because there was not a marriage. It's like retroactively looking back and say there was never a marriage. It usually relates to that there was some legal impediment to the validity of the marriage in the first place, but the parties didn't know. Or secondly, there was some lack of true assent. So say I was, one could be based upon my faith actually. Say I'm a member Z Church. I don't want to name any churches so I offend anybody. It's never my intent. But I'm a member of Z Church. I meet a young lady. We court. Things are going great. And early on, I tell her I'm a member of Z Church. And she says, so am I. I'm a member of the Z Church. And we go along and things are going great. And we go to get married. And I find out she's not a member of the Z Church at all. She just did it, I don't know, maybe thinking that was the thing to say, to fit in, to be kind. But in fact, she doesn't know anything about the faith whatsoever. And I learned that that's the case. Once I learn that there's something that if I had known prior, I would not have entered the marriage, I'm entitled to seek a divorce. You have to do it fairly quickly, though. What if I continue to participate as if I'm a married couple and we share a marital home and I don't act on those rights? Then that's called forgiveness, and the ability in forgiveness and or acceptance or waiver. The right of annulment will no longer exist. Usually annulments are done fairly early on in a marriage because usually figure out the impediment. Geez, I thought you were, or some, bringing up the old corny ones that were done in soap operas all the time. There's a man, let's go to a traditional couple, and a man and a woman, and the woman says, hey, I've gotten pregnant with you, and what do you want to do? Well, let's get married and have a kid. Well, you get married, and it turns out that the wife is not married at all. That would be grounds for annulment because it was based upon a false factual belief. Annulments are very rare on that circumstance. The other one's about legal impediments. You find out you're related. That's going to be pretty rare too. And because you're related, it's incestuous and therefore an illegal marriage. Or you find out your spouse that you married, you went through this licensing, maybe they have a new fake name. It's hard nowadays with all the Social Security identification to basically have aliases. But I marry my wife and I find out she's actually got another husband somewhere else. That's ground for annulment because you can't be legally married to two people. Annulment's not going to come up that big, but it does come up. I've done a few. It usually relates to a marriage. They got married very early on, and there's some material mistake of fact that the parties discovered very early on that affects their true assent to wanting to be married, to entering into that married contract, just like any other contract. Usually it's difficult to get if the other side objects and say, no, they knew all along, or I told them very early on, and they continue to stay in the relationship with me. That shows forgiveness and waiver or acceptance. So it's rarely done if the other party is not willing to agree that the grounds for an annulment have been satisfied. I'm just seeing if I see any of the other things about annulment. The next issue, I should have done this prior, is prenuptial agreements. These are now valid, I think, everywhere in the country. They weren't valid for a long time because they were thought of as a motivator to motivate people for divorce. So if I'm getting married and I meet somebody and I say, hey, let's get married, but perhaps I garnered some property in my time and I have maybe kids from a prior relationship, and I'm concerned that if this new relationship doesn't go forward and well and stay healthy, that we might end up in a divorce, or I might die while I'm married, and I don't want my new spouse, not for any reason of hatred or ill will, but I want some of the things that I've garnered over my lifetime to go to the children of a prior marriage. The prenuptial agreement will help protect some of those financial interests. And people say, well, since 50% of all people are going to get divorced anyways, isn't it a wise tool to have? I personally find them kind of repugnant. I don't know how you can go into a marriage bond, if you will, without at least the belief at the inception that this thing's going to last forever. But I get it with second marriages. You have, maybe both parties have kids from a different relationship, and they have a certain degree of wealth and assets that they want to pass through their children and don't want to risk their significant other in a divorce from potentially putting their interest into garnering some of that estate, if you will, that marital estate. Very, very dangerous. There's some different rules with a prenuptial agreement as opposed to other traditional contracts. One is it shouldn't just have one attorney. The attorney can't advise both clients, so both sides should have an attorney or access to an attorney. I mean, one party might be very wealthy. Let's say I'm going to marry a woman. She's an orthodontic surgeon, very, very wealthy, has a lot of money, and I'm just a middling sort of character, don't have much assets. Well, my new wife asked if I'd be willing to go into a prenuptial agreement because she has kids from a prior marriage and she makes a lot of money and she wants it to stay sort of in her wing of the family. And I think that's great. I have no problem with that. And then she hires an attorney to draw that up, but it's her attorney. That attorney is advising her. I don't have an attorney. That makes the agreement suspect because she has the upper hand, both in terms of what the results will be if that prenuptial agreement has to be applied. And secondly, she's the only one who has an attorney. That situation comes up. I always recommend that the wealthy party, the wealthier party, I should say, the one that's really pushing for the prenuptial agreement, not to hire an attorney for their spouse, their future spouse, but to give them the funds so they can go pick their own attorney and make sure everything is understood and basically an arm's length transaction between the parties. And the other is it really has to have fundamental fairness in it. It can't be shocking that one party's left as a pauper and now has to go on public assistance, while the other one's going to stay living in a mansion with winter places down at Key West, and ski lodges and Maseratis, and the other person's going to be walking on the street with a stick with a scarf folded around with like a little hobo bag and be homeless. We want to make sure that a prenuptial agreement is going to protect the core of the assets of one party over there without being so fundamentally shocking to the conscience. The other is it can't be rushed, it can't be forced. People have to have time to negotiate through the agreement. And here's the big one a lot of people miss. There has to be full disclosure. So when you're going to get a prenuptial agreement, and say I want a prenuptial agreement. I'm wealthy. I have some money from just living. The new wife I married, she's very poor. And I can't just come up with a well-written contract, give her funds so she can hire an attorney and have her look it over, because she's basically going to give up rights to things that she would get but for the prenuptial agreement. And so in order to do that, I have to do full disclosure. I have to list, and usually I used to do some prenuptial agreements. I would actually attach them to the prenuptial agreement called basically the disclosure form. And I'd say, I own this house, I have these bank accounts, I have these, retirement funds, I have these coin collections, whatever it is. And you got to be very copious. I mean, obviously, if you forget a few things. I forgot I had some roll of stamps in my desk. Let's not be ridiculous. But the core really has to be divulged to the other party. Otherwise, they don't know what they're giving up. They're signing rights, and even the party that doesn't have anything, including debts. You got to list everything out there so both parties can knowingly enter into a contract what's going to happen. Now, one of the things I want to stress, and I know in my family law class, I think some people miss this, prenuptial agreements have absolutely no impact on child custody or child support payments that are eligible. You can't waive child's well-being in the future. So say I marry somebody, say I'm a lot younger and there might be kids, and I'm going to say, okay, if we get a divorce, you get the custody and I'm not going to pay any child support. Yeah, you can't do that, because what if mom turns out not to be the best mom, and what if I'm available and can take care of them? And secondly, what if the financial situations shift and mom has no income whatsoever? Now she's raising the kids without financial support. You can't waive child custody or child support or even make out a schedule in the prenuptial agreement. It's totally invalid. Sometimes people put things in a prenuptial agreement that are invalid. And one of the things I always urge when you draft one of those contracts to say something is found to be illegal, and I'm not saying illegal like immoral, but just, turns out that that kind of clause would be unacceptable because of some new statute that was passed or just some new public policy in the state. You always put in that the rest of the agreement will survive and be severed from that portion which is deemed to be illegal. It's called the savings clause. I'm getting a little too deep. I apologize. So, and also the people have to be competent to not only enter into the marriage contract, but they have to be competent to enter into the prenuptial agreement. And challenging the agreement is based upon, oftentimes I didn't understand it. The other party had all the wisdom, and the attorney, it was a one-sided agreement, and it's fundamentally unfair. Prenuptial agreements are upheld fairly regularly, but boy, if they're very one-sided, there was only one attorney involved, and it was the attorney representing the party with the wealth, it's going to be looked at with a John Desai, and the whole thing might be thrown out. Save yourself some headaches and money and make sure both sides are represented by counsel. And there's some fundamental fairness. It's not like you get nothing if you get a divorce. It's just going to be maybe you keep certain things from potentially being subject of the marital estate, like previous house I owned. Maybe I inherited it from my dad, and I don't want my future ex-wife, if we should get a divorce, to have any stake in that. And you can put that in the prenuptial agreement. It would probably survive. Every prenuptial, I only like 5 or 6 of them. Every prenuptial agreement I did, they got divorced. And I say that it looks like I'm having, I find that enjoyable for some reason. It's not that, but I told every one of them that, I just, as a human being, I think when you go into a marriage and you sign up with a prenuptial agreement ahead of time, you have some doubts right away. But it's not always just about divorce. It's also about death. So if I die first, my wife won't make a claim to Grandpa's house because I wanted Grandpa's house to go through to my kids from a previous marriage, because maybe they grew up there, now they're adults, and maybe I have some kids that have some financial concerns with me. I don't think they're going to do that well down in the future, so I want to preserve some of the estate I have to pass through them if I should die prior to my wife. It isn't always about divorce. It's death or divorce. You can be very creative with a prenuptial agreement. Talked about annulment, marriage vows. You don't need at least in Massachusetts, you don't need a blood test anymore. I was just discussing this with a student recently. Blood tests used to be to test for venereal disease. A lot of people think it's to test to see how closely you're related for incest. That's not true. They don't do that. And they don't even do blood tests anymore in Massachusetts. That was 2005, something like that. They stopped doing blood tests because it wasn't screening out too much venereal disease candidates, so there's no longer a requirement to do a blood test. Marriage license, usually a waiting period. Go to the town where you want to where you're residing. Usually you pull the license. I forgot what the date. You should know about this. You're not usually going to be giving advice to clients unless you're doing the prenuptial agreement about going to get licensed. I'm just talking generally speaking. Oh yeah, we're getting married this weekend. Today's Friday. I better go out and get my marriage license. I think there's a little bit of a waiting period for that to happen. And then after the ceremony is completed by a duly licensed person, it could be civil, meaning like I did my daughters as a justice of the peace, or it could be a religious person, because most religious people are ordained and licensed to execute marriage ceremonies, and they sign it, and then they send it back to the clerk's office, and the clerk now keeps a statistical form showing you're validly married. Marriage vows doesn't have to be anything religious, or so you can be very fancy. I was just thinking about mine when I got married. My wife wanted to do all kinds of, all my friends are there, her friends are there, and my family's there, and I'm not comfortable, waxing poetically in front of all these people about love and commitment to one another. But some people love doing that. There's no requirement to do anything like that. You're basically just saying that you're going to be legally bound to one another, and that you consent and understand the obligations of what it is to be in a marital relationship, something to that effect. There is some language that has to be used, but it doesn't have to be all that sweet stuff. Talked about annulment. Common law marriage, I did want to talk about this because we don't have it. Most states don't. New Hampshire did for a while. It doesn't anymore. The only rights you get from cohabitating with somebody for a long, long period of time is nothing under marriage. You might have arguments that things were jointly paid for or nurtured and protected, and so therefore you might argue a partnership theory, which is a contractual theory, or you might argue actually a contract that's implied in law by the behavior of the parties. Very weak, because if you want the benefits of a marriage, you get married. That's the legal standard. That's what gays and lesbians fought so hard for. That's what interracial couples, for example, fought so hard for. They were denied a fundamental right to get the benefits of the legal status of marriage. So I've had this happen. My law partner we were doing an estate for somebody. The guy died, and the wife says, I'm having a tough time with the kids, and the kids are trying to kick me out of the house. One of these families are terrible. All families have these problems sometimes, where it surprises people after the fact. Like, well, how can they kick you out? And I said, well, your husband died. You were married like for 35 years. In the marital home, and it was only in his name. He goes, well, it doesn't matter. You're a spouse, and upon death, you have there's certain estate planning advantages about being a spouse. You're going to be all set. You're not going to lose the house. So I said, we got to go pull your marriage certificate. And she goes, oh, we have a common law marriage. And right away, because I've done this enough, I said, no, you don't, because we don't have common law marriage. And people insist upon it. No, we have a common law marriage. No, you don't. In fact, I was in court today, a criminal matter, and a husband and wife were involved. There was a minor domestic violence charge, and the wife wanted to invoke the marital privilege, meaning she did not wish to testify against her husband. That doesn't mean the government can't charge the defendant. Even if the wife wants it dismissed, the government could still go forward if they have independent evidence. But husbands and wives, one of the privileges of marriage is something called the marital privilege, and they can refuse to testify. And the first thing when they were in my office, I asked for, "Are you legally married?" And they look at me and laugh and goes, "Yeah, of course we are." Well, I don't know. People sometimes think they're married simply because they've lived together for a long, long time and have children together. There are no legal rights in the concept of marriage by cohabitating in most states in this country. There's a few in the Southwest that still have common law marriage. Very difficult to prove. You got to hold yourself out as a married couple and live for many, many, many years together and cohabitating. And the public has to be believing that you are, in fact, a married couple, and you have to bring in independent witnesses. Very, very difficult. Massachusetts does not recognize it. So in my case that I had today, I don't have their file right in front of me, but they did. They had a valid marriage license, so I was able to produce that to the government to show that Mrs. Smith does in fact have the right to invoke her marital privilege and not testify against her husband. So that's a big one. No common law marriage in the state of Massachusetts. The marriage relationship. Effects of torts criminal law, you can still be charged. You can't. At one time, you couldn't be charged. A man hits his wife, and the man couldn't be charged because the concept of marriage was two people become one. You can't be charged by crimes against yourself. That's gone, thank goodness, because people shouldn't be able to have the defense of being married from not doing crimes or torts to their significant other. So. Domestic violence is very big in our society. There's no question about it, and people should be held accountable for that in the right circumstances. Sometimes I think it's a family issue. The criminal court doesn't really belong there, but sometimes it certainly does, especially when you get repeat offenders really terrorizing their significant other, usually men against women, but sometimes women on men. But neither here nor there. The issue of domestic violence no longer can hide behind the shield of marriage without the couple wanting to invoke the marital privilege. And that only relates to testimony. It's a very narrow exception because we don't want it to be potentially a future division between a couple, especially when it's an isolated incident of minor squabble, for lack of a better way of saying it, where the police are called and he pushed me when I was talking about my sister, and I got scared, so I called the police, and they've been married for 30 years with no other incidents. Sometimes I think the marital privilege is very appropriate for that. But I'm not here to evaluate right and wrong. I'm just here to talk about the change that domestic violence is no longer protected inherently by simply saying, this is my spouse and I can beat him or her all I want. That's not true at all. Same with sexual violence. You can still be raped and be a raper if you're a married couple. There's no shield for that. Marital violence, some exhibits here. Now ending the marital relationship. Jurisdiction. Anywhere where anybody is residing, they can seek a divorce to end the legal status of marrying. So say my wife and I are here married in Massachusetts, we cohabitate in Massachusetts, and then as some people say, I'm going to have a midlife crisis, and I get a convertible, and I drive to California, and I start living in a tent off to some beach, and I take up surfing. And then while I'm out there, I said, well, I really don't want the baggage of being married. Can I file for divorce in California? Well, if I take up legal residence in California, I can actually file for divorce, even though there's no personal jurisdiction over my wife, because she's residing in Massachusetts and has no minimum contacts with the state of California, make it fundamentally fair. But the concept of a marriage flows with both parties, and either party can seek the end of the marital relationship, no matter where they live in any part of the country. But I can't get the court to order division of marital assets to force my wife to pay a part of her IRA or her pension fund to me, or divvy up the house. The court just wouldn't have the jurisdiction to do that. I know I'm throwing some people out, but generally jurisdiction is where the couple last resided as a married couple is the best place to file for divorce. So my wife and I said we're getting a divorce, but you look and say, where did you last live together as a married couple? Oh, we last lived together as a married couple in Gardner, Mass. Well, that's Worcester County, the probate and family courts in Worcester. Worcester would be the appropriate place for both personal jurisdiction over the party, but also jurisdiction over the subject matter and it has the closest nexus of where the parties last lived together, and that's part of the jurisdictional analysis. I don't want to get too deep into jurisdiction. Now, grounds for divorce. There are several fault grounds. They're still important to know because in Massachusetts, if you prevail on a fault ground, the victim of the fault, the innocent party, may have an advantage for child custody or a bigger division of the marital estate. Now, that does not apply to adultery. That surprises a lot of people, but there's case law in Massachusetts, say failing of the heart, having an affair won't have any impact on that party seeking child custody, nor will it have any impact on how much of the marital estate they're going to keep or lose based upon equity evaluations, which I'll get to in a minute. So, although you can still cite it as a ground, like I'm filing for divorce against my spouse because they're an adulteress, but the court doesn't really favor that because it gets no advantage for that party, and you have to prove that there was adultery. You have to actually prove consummation of a relationship with a third party. You have to call in the third party. It's a real nightmare. Courts really disfavor Massachusetts. Habitual drunkenness or being a chronic alcoholic and or dependent on drugs. This is dependent involuntary, so it's not like, geez, I'm on an IV drip because I have some very serious disease, and it is an opiate, but it's prescribed. That's not the grounds. It has to be something where you're basically willingly engaging chronically, not just he drinks too much every Super Bowl season and he goes on a bit of a binger for 3 or 4 days. No, it's going to be a pattern that would make any reasonable person feel like the sanctimony of marriage has been assaulted by the consumption of alcohol or drugs on a regular basis. That still exists in Massachusetts. Physical cruelty is the primary fault ground still used in Massachusetts. It doesn't have to be, I should say physical. It's actually called cruel and abusive treatment. It doesn't have to be physical. Physical certainly would be proof of it, and it's easier to prove the case if there's been physical violence, but it can be also mental, just somebody who's being very, very mean to the other party, and they bring up factors where an objectively reasonable person would have their emotions hurt, and you can prove it through everything by losing sleep, dietary changes, and you bring out evidence of what the conduct was. And it usually is not an isolated incident. This has to be a pattern of behavior that a reasonable person said that is cruel and abusive. You know it when you see it. Remember, family law is an equitable principle, and it's the most common one cited, and it is the one that if you can prove the other spouse was cruel and abusive, you might equitably have a better claim on more of the marital estate, and or maybe even a presumption that you'd make the better custodial parent if it's not going to be shared legal and physical custody, because the other party is an abusive person and they're cruel and abusive. But it's only a presumption because the other party says, well, maybe the court believes I've been cruel and abusive to my spouse, but I'm a superior parent, and that could be possible. I know someone say, well, it could be. Mental cruelty, that's physical and mental. The book bifurcates it, but we just call it cruel and abusive treatment in Massachusetts. Abandonment in Massachusetts is one spouse had to leave the other spouse for a year or more involuntary. It's not like they got sent off in the military for deployment, or they're a long-range traveler, they're a foreign diplomat or something like that, and they an ambassadorship to Ireland for 3 years or something, and well, that's understood. It's consensual. And the other is without explanation or just cause. So if the other spouse is chasing you around the house, get the hell out of here, well, that's obviously permissive. It's got to be without consent, permission, or just cause. The other party kicking you out and wants you out. Well, now it can't be. You can't cite in Massachusetts it's called utter desertion. You can't cite that. It's got to be 1 year of living without just cause, excuse, or permission from the other party. It doesn't come up that much. And the other one is insanity, mental illness, which does come up from time to time. Is a ground. You don't get any advantage, by the way. You do probably for child custody, but you don't get necessarily, I should get more of the marital estate as a result of the other party being mentally ill. And mental illness usually has to be a significant impairment to a healthy marriage. Most people suffer from some kind of mental health issues in their life. It has to be significant and chronic and impacting reasonably upon the health of a marriage. Now, the last one's not a cause at all. It's since 1974, I think, in most states, we opened up a can of worms. The divorce rate was much lower prior to 1974, but after 1974, we created something called no-fault divorce or irretrievable breakdown of the marriage, and that really, so when I was, well, I don't really remember because I was a real little kid when that happened, but but you watch movies of the era, which I do sometimes, and I'm always amused by people saying, I want a divorce. He goes, good luck getting one. You can't prove anything. And so you'd have to prove wrong. You'd have to prove wrongdoing. One of those things I just went over. You couldn't just go get a divorce because you were miserable with one another. But after 1974, you could. And let's face it, a lot of people were miserable, but they didn't go through divorce. One is there was a social stigma on divorce. It's really interesting in history how people who did get divorced in the 1940s, 50s, and 60s often were thought of as very negatively in the communities. It was really a cultural shift that we had in the 70s, where not only is the concept of someone being divorced not seemingly troublesome to most people, but you can basically get one if you just don't want to be married anymore. And no longer does both parties have to agree. A lot of people think, well, both parties have to agree there's an irretrievable breakdown of the marriage. No, you don't. One party could say, I'm madly in love with my wife. I think she's the greatest thing in the world. I can't wait for her ray of sunshine when I come home. And she can say, I just can't stand this guy anymore. I want a divorce. Can she get a divorce? Absolutely. There's a difference. One's called a 1A. Both parties agree that there's an irretrievable breakdown of marriage. It's a little quicker. It's a little easy for the court to get through. The other one's a 1B. One party is saying there's an irretrievable breakdown. For them, the other party disagrees. Doesn't matter. It's still going to go forward. But there's a hearing on the motion, and it's a little more challenging to do a division of marital assets. There's legal separation. I've actually done a few. They're very, very rare. This is where somebody comes in my office and says, me and my husband are having problems. It was wives I represented in these situations. And they say, I want to get legally separated. I said, well, you want a divorce? He goes, oh, no, I don't want a divorce. I said, well, do you think there's hopes of ever getting back together? And they tell me, no, I'll never live together with this man ever again, And then what it is either because of religious grounds or philosophical grounds, they don't want to end the legal status of being married to this other individual, but they want to legally define the rights and duties financially between the parties and the relationship of who may have primary custody of the kids, for example, and whether or not child support should be paid. And I was always surprised because I'm saying, well, why don't just get a divorce and file it? And they don't want to. And that's their prerogative. So there are people that seek legal separation. Just a word of warning. A lot of people think like, okay, me and my wife are going to get divorced. We file for divorce, but there's a process that takes time to get through. You just don't get a divorce the next day. So during that period of time, they think they're legally separated. No, they are not. You're still fully married. You might not be living together, and you might be going through the process of a legal divorce, but you are not legally separated. The only way to get legal separation is to file a complaint for legal separation, which most people don't. I used to do a lot of divorce work. It was probably 3 in my lifetime. Temporary orders. This is very important. So say parties are at odds. They can't stand each other. There's a lot of fighting going on. Who's going to stay in the marital home? Who's going to maybe go and get an apartment or a different home? Where are the kids going to stay? Well, if the divorce is going to take months, if not a year or more to resolve, we have to get temporary orders. The warning here I have to give you, if you're going to be a paralegal and attorney, temporary orders tend to become permanent orders, meaning that, okay, Dad, we're going to, Mom and Dad are fighting. Dad, you're going to stay home at the old house we had. Mom has a good career out in, say, the eastern part of the state. She's going to move. She's going to have a lot of visitation, but primary custody is going to be with Dad. That's the temporary order that we're going to draw up by agreement. Well, if things are working, what do you think is going to happen a year from now if we can't come up with a new system? I'm going to fight to keep primary custody. Mom might say, well, I want primary custody now. That was only a temporary order. The court's not going to want to change the situation for children if it's working. They need a substantial change in circumstances to disrupt a situation that's working. So be very careful of thinking temporary means we're just going to do it for now. It'll change rapidly. Temporary orders tend to solidify. It's kind of like Jell-O. Over time, it's going to get really hard to to reshape that mold. So whenever I do temporary orders, I'm very, very cautious to make sure we don't do anything that we can't potentially live with later on down the road, because the court may not want to mess with that. And of course, the parties are always free to agree. That's the happy divorce, which is rare. They sometimes start off happy until people start seeing numbers and dollars and the emotion of custodial changes taking place, then things fall apart. But if the parties agree, they can agree to everything with one major exception. They can't put the kids in jeopardy. They can't say, okay, Mom, who is totally unfit, never home, and addicted to very serious mind-altering drugs, yeah, she can have custody, and and that'll be great. And I'm the better parent. For whatever reason, I'm manipulated. I'm under, uh, maybe some kind of undue influence, so I make this ridiculous decision. So the court wants to review the appropriateness of it. But other than the review of the appropriateness, the couple can agree on everything with relationship ending status. Okay, we're going to get divorced. Kids are going to primarily live here. This is what the child support is going to be. But the court will review the child support to make sure it's fundamentally within bounds of what we call the child support guidelines, because guidelines are in Massachusetts. The court will not let the payor, the one who doesn't have primary custody, pay less than those guidelines, even if the parties want to agree to it, unless there's some very unusual financial situation that makes it equitable and fair to do so, because the judge is going to have to make written findings why they're going below the baseline, because you can't give up your children's financial security. And the second is custody. Okay, they're going to primarily live with mom. And you agree with that, sir? They go through it. And mom's a good parent. Yeah, and you go through it. And dad, you're going to have substantial time with the kids. Yeah, and a lot of couples try, and we'll get to that in a minute, to do joint physical custody where they share it equally. We'll get to the strengths of it also. Be careful on the temporary. Well, now we are in custody. Who gets custody? If the parties agree, the court will usually go along with it as long as the parties are fit to be parents and available to do so. There is a new presumption in Massachusetts that we push for joint physical and joint legal, where the couple share as equitably as possible shared physical custody. The only issue with that is, it sounds great, and when I first got into family law, I think that's what we always wanted to fight for, but it affects child support if there's not a primary caretaker, meaning the home is primarily going to be with mom or with dad, and it's usually the primary caretaker that gets I would say rewarded, but gets the child support. And that can be altered significantly if it's shared physical custody that's equal. Well, some couples, if they're getting along really well and they live in the same community and they're thoughtful people and money's not going to be that contentious with them, which is rare, you can have shared physical custody. In fact, there's a presumption for it. The courts are trying to move to that. But the thing is, if the parties don't live in the same school system and they don't have proximity to one another, it's very difficult to flop 1 week on, 1 week off, or 1 month, or I don't know. I've known people who have tried to go through. It's very, very difficult unless you live in the same community or close by. Because let's face it, you've got 3 kids. They're with me this week, and at the end of the week, I drop them off to mom. Let's hope we're amicable, we're getting along. And then guess what's going to get the phone call the first day the kids are over there and say, "Hey, I left my retainer back at your house. I need my book for English. I left it under my bed because I didn't look at it the whole week I was with you." It's just very, you have to have 2 sets of clothes, two sets of toothbrushes, 2 sets of entertainment systems, 2 sets of everything when you have kids sharing 2 different homes. And it's a very, very challenging situation. So you need also couples that are divorced now who get along. And they have to get along very well. Well, my question is, if they're getting along that well, maybe they should think about staying married, because if their marriage ended because of contentiousness and challenges with one another, are they suddenly going to be these super people that can really get along in these situations where, Junior forgot his thing at your house? Can you bring it over? It's always that issue. Can you bring it over? No. Can you come get it? It's just a nightmare. And speaking from experience, not just as an attorney, but as a person, I had that. It's very, very, it's daunting to do it. But if the couple can work it out, maybe it benefits the kids. And I think divorce is tough on kids, even if kids think, "Oh, geez, we don't want mom and dad together," because they don't, and that's the argument. Mom and dad together are worse than mom and dad apart. But it's still a very, very big challenge. So who gets custody if they can't agree? That's if they can agree. This is if they can agree. They can't agree. Now you're asking the court to make a decision. And they do something. One time there was something called the tenure. There was called the tender years presumption, that mothers really should get primary custody of very young children. I have to admit, I still have a sociological, cultural bias that mothers of young children probably, I lean towards them unless I hear facts that are contrary to suggest dad might be a better choice. That's illegal. Men and women are equal before the law. So what does the court do to determine mom and dad are here? They both want primary custody. They can't come to an agreement to shared legal custody and physical custody. They're always going to have shared legal just about major decision about whether kids should have some kind of surgery or where they should go to school, the religions that they might be raised in, things of that nature, trips far away out of the country. Those are legal custody issues. Almost every parent, even parents that are not so great, have shared legal custody. It's the physical placement. Where are we going to have these kids go? If the parents can agree, fantastic, the court will go along with it. If they can't agree, the courts might order joint physical custody, but again, usually the couples need to really get along to make that happen. Let's assume they can't come to this agreement, and the court's not going to order, or the court might order shared legal custody, but how are they going to make a determination where should the kids go? They're not going to split the kids either. Okay, I'll keep my daughter. You keep our. I'll keep our daughter. You keep our son, and because that we get along better, and you get along better. No, the siblings need to stay together. So you can't get too creative with it. But let's assume we can't get an agreement, and we're going to fight over it. The judge might order joint physical custody if he or she thinks it's going to be appropriate. But how do they do it? What's their rubric? What's their analysis? They look at the best interest standard. There's no longer 100-year presumption. There's no presumption in favor of mothers or fathers. Fathers for boys. People say, well, when a teenage boy hits a certain age, he should be with his dad. That could be a factor, but there's no presumption. So they look at what's called the best interest. Best interest is very vague. Remember, it's a court of equity. They do what's fundamentally fair under the circumstances. And they look at everything, the bond between the children and the parent, or the child, could be one child, the time available. I've had many good people say, well, I want primary custody of these kids. I'm like, great, you sound like a great mom. And they'll say, well, geez, Mom, you're a flight attendant with TWA, or you're not even home in the region half of the year. How could you possibly have primary custody? Let's let dad have primary custody, and you have very, very significant visitation, especially during vacations and things like that. And you have opportunities to make visits over the phone. That's actually a form of visitation. Phone and texting and face chat, whatever it's called, FaceTiming. And boy, is it horrific. I really don't like doing family law because I just feel the pain that people go through. And it really is just such a challenge when you tell people, you're not going to get primary custody, you're just not available. So one is availability. The other is the ability, I know this sounds corny, how do you measure it? The ability to nurture, to be available, to give guidance. And they look at things like even education. And, well, how about a home? All right, mom and dad are split up. Dad takes off. Now he's living in a 1-bedroom apartment. And there's 3 kids. There's 2 girls and a boy. And dad's got the bedroom. Well, the kids all got to couch it out and be there primarily. Dad should probably have a lot of visitation, but maybe because of the housing situation at this juncture, they'd be better off with mom. And here's the other thing that is kind of good news. Custody can always change, but it has to be substantial change in circumstances. Suddenly dad gets a house, he's got 3 bedrooms, he's closer home, and his job has shifted, he's much more available now. Now maybe we can change custody. Again, changing custody is a little bit challenging to show a substantial change in circumstances. So all of these things, religious, I don't know how much it plays in, but it does. Cultural opportunities in the town that you live in might be different than where the other spouse lives in, or parent, I should say. And all of these factors go in there, and the judge makes a judgment call. And they actually have 15, I think 17 actual factors written out in some case law, and the judges are supposed to check off each one that they've considered, availability of funds. Domestic violence is big. If one of the parents has been charged and convicted of domestic violence, they're not getting primary custody. Doesn't mean they're not going to get custody. Doesn't mean they're going to have time spent with those kids. But boy, it's going to be a very, very tough road to hoe to argue you should have primary custody of kids when you've acted violently upon the other spouse, the other parent. There's a presumption in the law against granting custody to convicted domestic violence people. So, but a presumption can be overcome, but just like any presumption, it's a high hurdle. So all of those things go into play. And again, if they don't work, meaning so the court makes an order, one person is usually disappointed. And that's the other thing I always tell my client too. It's much better if we can really try to hash out some kind of an agreement. Otherwise, there's a stranger up there, a judge, who doesn't really know the couples, doesn't really know the kids. And kids do not testify. I mean, it does happen in a very rare amount of cases. I've never had it happen. I did it for like 25 years. And everyone threatens, I'm going to bring that kid in there, and they're going to say which parent they want to live with. They might have a guardian ad litem, an investigator, basically go out and talk to the kids to help the judge make a determination where the best interests lie for the kids to live. But the kids shouldn't be able to really manipulate the situation by their decision, because they say, yeah, I want to live with dad. Yeah, it lets me, drink half of his beers when they get a little warm, and lets me play, Black Ops until 5 o'clock in the morning, and we eat donuts for breakfast, dinner, and lunch. And sometimes we have green sprinkles on them, so I get my greens. That might be where the kid wants to go. There's no doubt. That doesn't mean it's in his best interest. We consider that as part of the analysis, is the kid's desires, but we're not going to bring the kids into court to testify. What a horrific idea. There's mom and dad sitting in court with a judge, maybe the public, and they're going to bring up a 10-year-old kid up to the stand and say, okay, Bobby, where do you want to live? You want to live with mom mostly, or mostly with dad? It's child abuse. They don't do that. They sometimes do have inquiry to other witnesses where they can say, the child often says they favor being with mother and dad. And sometimes it's just like, geez, when they stayed with dad, the kids were thriving in school, but then they stayed with mom for a while and the grades went down. Well, is that part of the evidence? Yes. Everything can be considered by the court to determine the best interest for kids. I already talked about joint physical custody orders. That's another nightmare. I've done some divorces and finally have an arrangement worked out where either the court is ordered or we come to an agreement. And it's an inevitable call, late at night. Now with modern cell phones, thank God I don't do divorce work anymore, but back in the day, before cell phones, you'd see that you got a message on your answering machine Monday morning and come to the office early, and it's my client saying, really upset that her husband, the dad of the kids, we're supposed to bring the kids home on Sunday night at 6 p.m. so they could be ready for school. And he came back at 9:30 because they were having a hootenanny at a time at some festival. I want to bring my ex-husband in for contempt of court. Well, that is contempt. You violated the order. The agreement becomes an order. But in most of those circumstances, I try to ask both clients to, really try to follow the report or the order as best as possible, because on something like that, although one party is in contempt, they violated the strict terms of the agreement, the court's not going to probably do a heck of a lot other than yell at everyone to grow up and become more responsible, try to do a better job at either abiding by the agreement or having flexibility in the agreement when those times come up. And you'd be surprised how bitter people are when you have a divorce for 3 years and things I think are going kind of along, and one party says, well, I want to take an extra week in the summer, but I'll exchange another time because I've got tickets I bought for the kids to go to whatever it is, Disneyland or Disney World. And I'm like, but my ex-husband won't agree, or my ex-wife won't agree. And we actually have to go into court and say, Judge, we're not trying to limit the other party's access to the kids. Just this 1 week, the mom or dad doesn't have plans that week. It is their week of time with the kids, but we're offering a different week at a different time so the kids can get this benefit out of it. And the judge will usually grant it. But why couldn't the parties just agree to that? It's filled with angst and anger, and good people become unreasonable through the divorce process. That's custody. And how much is child support? Well, if there's one party with primary custody, they're usually the ones that are eligible. But sometimes the one with primary custody, if the financial situation is so askew, they actually might be paying child support to the party with what we call secondary custody, or we don't call it visitation so much. I mean, we call it shared custodial, primary, secondary. We're trying to change the terms to make it a little somewhat palatable to people when they don't have the primary custody. But it's all formulatic if the parties can't agree. There's guidelines for it based upon the parties' incomes. Yeah, child support guidelines. Very strict in Massachusetts. One of the highest states in those of you that might be getting child support don't think it's so great, but it really is a very high standard. A modification of support, so maybe mom's paying child support. She's an orthopedic surgeon. Dad was a primary homemaker. He's got primary custody now because that's what he was. He was the primary homemaker. He was primary with the kids. He has a stronger bond with the kids. He's available. Mom's paying, really probably a significant amount of money for those 3 kids because their income is so large. And then all of a sudden, mom loses her job as an orthopedic surgeon, or she always had the goal of making a career change, and she wanted to be a professor of, dental surgery at some school, and maybe it pays a lot less than what it was a career out in the market. she's entitled to a reduction of child support, but she has to go to court to seek it. If the parties can agree, they'll just draw up a modification agreement and just submit it to the court. Don't have to even have a hearing on it usually. But if not, it can be contentious, and you can argue things like, oh, she left her job just to reduce child support. It's not like a legitimate planned career change, and that's the kind of thing the court has to go to analysis of, because if it isn't a legitimate career change, the court can do something called imputing income, saying you could be making that same amount of money, but you're making a voluntary decision that's not in the children's best interest, and I'm going to make you pay the higher amount, basically force you to go back to the other job. And those are the kinds of trials that people have over that modification of child support. Failure to pay. If a person doesn't pay without just cause, I got laid off, I can't pay, you're not going to be in trouble for that. You'll pay less. But usually you have to notify the court so you don't get in trouble. But say you just refuse to pay, maybe you're self-employed, so DOR, Department of Revenue, doesn't take with wage withholdings from your employer. You're self-employed, so you have to pay directly, and you just decide one day, I'm tired of paying her money, I'm not going to do it. You're in contempt of court. You can actually be sent to jail for a period of time for that. But prior to that, they can remove your driver's license. I have a client right now, matter of fact, today, he has been caught several times for driving with a suspended license. I will get your license. They won't give it back to him because of child support. I said, well, let's start making some headway to child support to make you eligible to get your license back. They can take away professional licenses. I've known a plumber that lost his plumbing license as a result of failing to pay child support willfully. Lawyers, you name it, you can lose your license. They can garnish your wages. They can freeze your bank accounts. And they can eventually lock you up for criminal contempt. It does happen. Now, how do we division? So let's assume now that's a child support thing. That's completely separate. We do not have community property estate. We're what we call a whole estate or a common law estate. Most states are common law estates. Everything you own prior to marriage, during the marriage, inherited, it doesn't matter. It's part of the marital estate. That shocks people. So I get married tomorrow, and I have all these things that I've inherited from my parents or that I've earned through my own independent means throughout my entire life. Now I marry tomorrow, and next week I want a divorce. We have a marital estate. What does it include? Everything. Everything I've ever had, inherited, gifted, worked for. Same with her. It's now part of the marital estate. Now, what makes it fundamentally fair, I believe in the end, is how are we going to separate this ball of wealth between the parties? No, it's not 50-50. It's equitable. And so it'll look at things like contribution. Who did what to put this ball of a marital estate together? If I did most of it, and it was a very short marriage, I'm going to get most of it out. Same with my wife did that. She contributed much more to the marital estate. She's going to take much more out in a short marriage. Why am I saying short? The longer the marriage, the more likely both parties did things to contribute to that marital estate, did things to protect it, to nurture it, to repair it, and therefore it's getting it closer and closer over a long marriage to be a more even split. But it's always not even. Don't say it's equal. It's equitable. So if both parties worked at similar income jobs, they were married for 30 years, they both got the mortgage and they shared the mortgage, they put new roofs on it, they bought cars, they had pensions, and they contributed equally to the cause, and they're going to get divorced after 30 years, it's probably going to be close to 50-50. But if it's a short marriage and one party came in with a great deal of assets and wealth, and the other party did very little to contribute to the protection, the enhancement, or the actual contribution to this ball of wealth, if you will, the marital estate, they're going to get a lot less. It's really not that inequitable of analysis if you really think about it. Community property estates, everything you owned before you got married, you keep on the date of divorce. The only thing that needs to be divided is everything you garnered from the date of marriage to the date of divorce, and that's split 50-50. Much easier analysis in community property estates. The only thing that gets a little confusing in community property estates is, well, what if in a state I own this house, I get married, I'm in a community property estate, but then while we're married, my wife helps pay for a new roof on the house, and then she paints all the downstairs rooms and wallpapers some things, and she's really creative, so she did some tiling down in the bathroom. Now the assets is commingled in a community property state. Now we have to figure out how to, it turns into an equitable analysis in those states. We are not community property. We are common law. We are a whole state. We consider everything everybody owns, and then we figure out how to not divide it, how to distribute it based upon these equitable principles of contribution. Another thing too is like, all right, now I'm leaving. Do I have the ability to earn more income because of my background as an orthopedic surgeon, where my wife gave up her education to largely raise the kids and be a homemaker? Now the kids are grown. She's at an economic disadvantage. So would it be more equitable to maybe give her more of the marital estate in light of the contribution she made as a homemaker? Yeah, it's not just financial contribution; it's contribution to the marital identity over the period of time of the marriage. Same with marital debts. If I didn't know my wife was incurring debt upon debt upon debt because she shops at Amazon every 15 minutes and there's always a new box outside the door and it's things only for her use and enjoyment, and then it's all apparently going on a credit card, and then we're divorcing, we look at debt as well. Who's going to be responsible for the debt? It's based upon things like, well, how did the debt get incurred? Who benefited from the debt? And the length of the marriage and things of that nature. And just quick on alimony. I don't want to get too deep on alimony, but alimony, usually a lot of people really dislike it, find it repugnant and inappropriate, unless you're somebody who understands it a little bit, because it actually is an equitable principle. You have a couple come in, and let's assume, I'll just use myself. I marry an orthopedic surgeon. She's making $300,000 a year. I'm going to raise the kids, and I do. And now the kids are all grown up. They moved out. And now, as a result of the kids moving out, we realize we have absolutely nothing in common. So it's time to divorce. I'm not going to get any child custody. I'm not going to get child support either, because the kids don't live at home anymore. I'm not raising kids anymore. I have no income. I have no education. Maybe I have a bachelor's degree in English. Maybe I can go out and teach English at a high school or junior high or maybe elementary school or something. I don't know. But I'm older too, right? I'm getting old. My wife's got all this income. We divide the marital estate equitably. But after that, I have nothing coming in. I don't have a job. And yeah, maybe I got some money out of the division of the marital estate. I got some of the, my wife's retirement funds or 401k or savings accounts. Well, that's going to run out. And I was accustomed to living in a certain status, in a certain standard of living for my life. And so is my wife. We're both way up here as a result of her income and me managing the house. Now, upon divorce, if she gets to keep her $300,000 a year and I have no income, I'm going to be really in trouble. It would be more equitable to say, all right, Jim, you were up here, living up here high. As a result of divorce, you're probably going to drop down some, but let's make it fundamentally fair so that, you both kind of stay as close. In order to do that, the wife's going to have to pay some alimony. Massachusetts did some alimony reform in the past, probably over a decade now, where there's time limitations for how long a person can get alimony. So what's the analysis, though? We want to keep the parties in a close station as they were in life by making an equitable distribution through alimony. The payer of alimony gets to write it off on their taxes. The recipient of alimony pays tax on it. On child support, the payer of alimony does not get any deduction on their income tax, and the recipient of child support does not pay income tax on it. Alimony doesn't come up in that many cases, but every so often, as I was involved in, not as an attorney, but as a friend I knew very well, husband made very, very big money, hundreds and hundreds of thousands of dollars. Mom raised 7 kids. Kids were all moved out. Dad, but for whatever reason, Dad wants a divorce. Dad gets a divorce, and he didn't want it. And he let Mom have the house, which I thought was, fair, quite frankly. But he left with, the most of the money and the income. He still had a huge income. Mom graduated from high school back. This is a case from a long time ago, but say they both graduated high school, like in the 1950s, I think. He went on and got several college degrees while Mom was raising the kids, and he got tons of income and got a great job. Mom is a high school graduate from the 50s, has no real technological skills or anything like that. And it went through the court system, went to the appeals court, and the appeals court said, of course, the husband has to pay some alimony. Her contribution to raising those kids and giving up a career is going to leave her impoverished after the divorce. There's no flow of income, and it would be inequitable to allow him to keep this $400,000 a year job going on when she has zero. Nothing. And so the formula that we have in Massachusetts is, in order to even be eligible to receive alimony, there has to be at least a 5-year marriage. And then there's timelines, a marriage from 5 to 7 or 5 to 10, then 10 to 15 and 15 to 20. And then again, how much the party with greater income has to pay the lesser party is determined by the equitable factors that go into the situation, very similar to the division of marital assets. Who contributed what? Did the other person just be lazy, or were they raising the kids? Those are kinds of, and then, for example, I give an example where I had a bachelor's degree. Maybe over 4 or 5 years, we're married 15 years, I could get a master's degree and I could earn a fairly decent income. So the alimony would be paid for a period of time. So it's called rehabilitative alimony to get my feet economically so I can be productive on my own. What kind of analysis we doing this thing? Knowing and surrogacy, I'm not going to test on that. Oh, and just as an ethical consideration, law firms should never represent both of the parties on a divorce. It should only be one party. Sometimes people try to get away with it. I've had two clients come in and not holding hands, but they seem very happy. That's what's going on. He goes, so we heard about you. Yeah, what's up? Because we want a divorce. I said, from each other? I was thinking maybe what is the new significant other? He goes, no, yes, from each other. We want a divorce. We're getting along. We have it all worked out. We just want to get through legal processes. Well, I can only represent one of you. The other one's going to have to leave my office because there's confidentiality of information. Remember that from a previous chapter. I said, and I urge the other party to hire an attorney. And then they say, well, can't you kind of represent both of us? We heard you're trustworthy and you're ethical. Well, yeah, that's why I am ethical. I only can represent one of you, and I'm not going to be comfortable doing this divorce unless the other party hires an attorney. Most of the attorneys in the community I know go out and hire one. I'm not going to recommend anybody because that's unethical, I think, in that situation, because it could turn into an adversarial system. So attorneys should not represent both parties. It's how they get out of it sometimes. They, well, I only represent Mrs. Jones, but they'll tell the other one, but Mr. Jones, I'm going to represent you two off the record to make sure it goes through. Unethical. Don't get caught up in doing it. Represent one side only. Don't play hardball if the other side decides not to hire a lawyer. Once ago, it's called pro se. You still treat them equitably fairly. Don't take advantage of their lack of an attorney, but you really want to urge them to have independent counsel so the court doesn't look at a potential agreement or just the trial process as fundamentally flawed because there's not representation being provided for the other side. Boy, did I go a long time. I apologize. I hope it's worthwhile for you to watch or listen in the background as you do maybe more important things. Best of luck. Thank you.